So we're looking at elements of a trust, and the elements of a trust are that we need an intent, a purpose. So the intent is for the benefit of the beneficiary to receive whatever it is that the grantor wishes the beneficiary to receive through the trustees. Then we have the purpose. Well, the purpose is that this will enhance the quality of life for the beneficiary. And then we have the parties. So we have the grantor, we have the trustees, and we have the beneficiaries. Then we need what's termed the res, which is the property, or it's not so much the instruction, but it's the acknowledgement or the granting of. It can be in written form or it can be an oral declaration. So it could be, if I ask someone, is there any chance that you could do something for me, for my friend? And they say, yes, it is. Then I've granted them a service and they now going to act upon it for me, for my friend. Now, if they don't act upon what they've said, because I'm drawing on their conscience, that they've said yes, I've given them an opportunity to say no. I haven't, forced or tricked. I've just asked, can you do something for my friend? And then they've said yes. So now my conscience tells me that I can trust them, and they're now the trustee to bring whatever it needs to be performed as an obligation to the beneficiary. So it can be as simple as that. But then there are many complexities of trusts, in that there are complex trusts, there are express trusts, implied trusts, secret trusts, the half-secret trusts. There are many different forms of trust relationships that can be recognised in law. So we need to start recognising how we're operating in a day-to-day basis. Are we being the grantor? Are we being the trustee? Or are we being the beneficiary? So in relation to this scenario where I may ask a friend to do something for another friend, now there is actually a cross-trust relationship where this guy has granted his service to me. Now, I have a duty, an obligation as a trustee then to this beneficiary to make sure that the duty is performed by this guy who's now a grantor, and he can pull out of the situation unless I've specifically put it in the instructions that he's agreed to. So it's something like a contract. It's a little bit more loose, but it would be deemed more like a contract in equity. So that's just a little introduction into what the positions are in a trust relationship. And then we're looking further lectures of how trust law has been hidden, it's been statutized, and the reasons why the state have assumed control over the people when really the state really owns the citizen, and the people are the power that energize the government, if you like, for them to operate the society, as it were, or the cities and the citizens for the benefit of the people. So we're going into equity, which is very much it's deeply steeped in English law, and we're trying to what's the word, sort of like reintroduce people into what equity is, whereas maybe 100, 200 years ago people were aware of what equity was. In fact, that was how equity blossomed, was through the trust relationships between people, where common law only gave the ability to leave land to the eldest son. It was not always seen as the best policy to leave the land to the eldest son. And then the crown had arrived through William I and was trying to encroach on the land. So people started forming trust relationships. So we'll be looking a little bit about the history of trusts, and then we'll be going into what effect it had on the governments or the ruling sovereigns of the land, in that they couldn't really poke their nose into private business, and they could never understand why, because they always had a assumed authority over people. So we'll get to that next time.